is up? Welcome to the Transparency Thursday all day today, September 18th. We got some breaking news. Jose Baez called it back over a year ago. He said that there would be jailhouse informants. That's what comes next. Shanna Gardner, so Florida versus Shanna Gardner. This is the murder for hire case out of Jacksonville Beach. Shanna's ex-husband, Jared Bridegan, was ambushed, gunned down, and murdered after dropping off their children after a Wednesday. They shared custody of their kids, and on Wednesdays they had date night. If it wasn't your week with the children, so it wasn't Jared's week with the children, and so Wednesday he came and picked up the twins. Jared Bridegan and Shanna Gardner had twins. He came and picked up the kids for dinner, took them to dinner, brought them back, dropped them off at approximately 7:45, and then 911 calls would go out just before 8 o'clock. So, welcome back. But Jose Baez called it, and he said that after the government is going to do crazy, wild things, the next thing you can expect to have happen is there's going to be jailhouse informants. Now, this case was supposed to go to trial in October of this year, 2025. It got pushed back and delayed due to all of the discovery issues, which we're going to bring up. So the latest in breaking news is that right here, Diane out of Columbus, Ohio, one of the best trial litigators. Jose Baez has worked with her before in the past. Jose Baez, Shanna Gardner, add Diane to the ticket. I'm going to make this bigger for you guys. Rep in Ohio here. So Diane is a trial lawyer who has tried more than 150 criminal cases and civil cases to jury verdict. Her and Jose did a case together back in 2022. He was actually pro hoc vice on her license here in Columbus, if you guys want to look up that case. She was also Matthew Moore's attorney. He was acquitted of killing his wife. Back in 2022, they represented a doctor from Mount Carmel, and he was acquitted of over double-digit murders. But her work includes high-level criminal defense in state and federal courts, complex civil litigation, which this is a very complex case, internal investigations, parole hearings, judicial release motions, and juvenile criminal defense. Annually, Diane is a faculty member of Harvard Law School's Trial Advocacy Workshop, where she teaches alongside some of the best trial lawyers and judges in the country. So again, you can find out all. You would go ahead and check it out if you want to read more on Diane. Phenomenal pickup there. Shanna Gardner has, when you want to talk about a team, holy shit, a team. Not only does she obviously have Jose Baez, and Jose Baez is a squad around him. Okay. She went out and got attorneys, and this isn't the first one that's going pro hoc vice for her. So that she has a squad. Also, I think Mario Saldana is reaping the benefits of Shanna Gardner's defense team. He's been able to piggyback a couple of the motions throughout this pending proceeding. Jared was shot and killed on February 16th, 2022. So it's 2025. Okay. This case is a little bit different in terms of you have co-defendants who were married, Mario Saldana and Shanna Gardner. They got married, so they have privilege with that. There is a hitman named Henry Tenon who was arrested off of, not for the murder, but in August of 2022, so 6 months, not even after the murder, he was actually detained and arrested for traffic violations. Then he remained in jail from August 18th of 2022 all the way until he was then charged in January of 2023 for the murder of Jared Bridegan. Then just 2 weeks after, February 1st, he cuts a deal with the prosecutors where he was going to plead guilty to second degree, and he was going to be getting a 15-year minimum sentence. Could possibly go to life, but that's not what I read in the papers. And in turn, he's going to testify against none other than Mario Saldana in this hired hit. Mario Saldana, like I said, was the new husband of Shanna Gardner after Jared Bridegan and Shanna Gardner divorced, which they went through a nasty divorce for 5, 6, 7 years. So it would not be, though, until March, in the middle of March of 2023, that Mario Saldana would be arrested. And then Shanna Gardner would be arrested in August of 2023. And so then here we are in September of 2025. We were supposed to have a trial in October, like next month, like after I was going to be doing the Idaho 4 case, I was going to be jumping into this trial. Well, this trial got pushed back due to discovery issues with, there's a whole bunch of them. We're going to get into that. We're going to get into the jail informant, and we're going to get into the depositions that have taken place. We're also going to get into Henry Tenon backing out, allegedly, of saying that he gave a false confession, basically, and there's more to that. So we'll get into that. But Shanna Gardner was supposed to be facing, and so is Mario. They're facing the death penalty. So this is a capital case. After they arrest Shanna Gardner, within days, they file that they're going for the death penalty. Shanna Gardner then, after it became a death penalty case, she then hires Jose Baez. Jose Baez puts his team together. And then here, just literally on September 15th, 2025, does he bring on Diane. So, all right. We are going to first bring out this motion here. Well, we're going to go over to Hector. So good morning. Come on in. Hector, what you got for me? Oh, we got a bunch of discovery there, but we're going to start right. Okay. So back a couple months ago in May of 2025, the prosecution wanted to take pictures of Shanna Gardner's tattoos. So they put in a motion to take pictures of her tattoos. Due to all of the craziness surrounding this case, Jose Baez, though, prior to all of this taking place, back in June of 2024, he had Shanna Gardner fill this out, which is notice of invocation of constitutional rights. So this was after Jose Baez did his press conference on the steps. Okay. He knew it was coming, and he wanted to put it in writing and let everybody know at the jail, with the prosecutor's office, that Shanna Gardner is represented. But more importantly, Shanna Gardner will not be participating in the following. Shanna Gardner unequivocally states that I do not and will not agree to speak with any jail psychologist or anyone in the ministry and employment. So it goes down, consent to appear in any lineup showing. I mean, he literally had this written up. Consent to interviews or communications with the media. consent to any polygraph or voice stress. I mean, they were just literally doing everything and putting it all in writing because of the fuckerage that has gone on with this case since the investigation began. So this was put in literally June 21st, 2024. This wasn't something that was put in when he got hired, okay? And when she was arrested in 2023, a whole year goes by, right? And it's like he called it. He said on those steps, he's like, after you try to do this and you're lying on the stand in, bond hearings and you're threatening witnesses, you're keeping witnesses from us, everything that Jose Baez was talking about. He's like, the next thing that's going to happen is you're going to have jailhouse informants. And Jose Baez was 100% correct that that's what was going to come out. And so let me first back up and tell you guys that, okay, so this case, like I said, it is so complex because they didn't arrest Shanna Gardner or Mario for what, 2 years? Well, a year for a year and a half. But during that time, they were doing wiretappings. Okay. They obviously were interviewing people. They were performing subpoenas and search warrants and getting phones and geofencing and all that, everything that you could possibly imagine. We're going to go through all that. So all of this, like, you're building a case to then arrest somebody. Okay. Which I will tell you this, that's what I like to see, that you build a case against somebody, you don't arrest them and then build the case after. You're building a case against somebody, you're building actually probable cause to then arrest somebody so that, you can actually go to a preliminary hearing and be bound over then for trial. Okay. However, a couple of things can happen though when such time goes by, is that when you are arrested, when your lawyer comes in and they would try to go and get, let's say, surveillance cameras from different areas, things like that, you're coming in, that stuff isn't going to be available. It's a year and a half later. So from a defendant standpoint, I think there's a downside to that, but okay. So the last major update was the defense team saying, listen, there's a woman named Susan Lee that Detective Johns lied about. There's text messages that were put up and made an exhibit, and you guys took the LOL off of the text messages that were supposed to be meant for a joke. You put them up in an exhibit. We believe that Detective Johns lied to the grand jury. Because if he testified like he testified here today in this bond proceeding, this Arthur hearing, and you guys testified to the same stuff at the grand jury, then we know that he committed perjury. So in Florida, how a couple of the rules work here is, in Florida, you're allowed to depose people. So the defense team has been doing depositions. We're going to go over everybody that they've deposed. That should tell you who's important in the case. And that is just who they depose up to this point right now. They can still be doing depositions. So we left off with the defense team saying, listen, not only did you misrepresent Susan Lee's statements, KJ statements, Jensen statements, you then made these exhibits and you put up on the screen text messages from literally 2025 or 2015, 2016, 2017, so outdated, but you literally took off the LOLs off of like these text messages. And I'm over here like, wow. Like, that to me is the most important part, is that you're taking off the LOL in showing the back and forth between Shanna Gardner and Kim Jensen. That is absolutely crazy to me. I think that that when you mix that in with then misleading when Henry Tennant got checks and the dates of those and making it seem like it was a year that it wasn't. Again, they put in a huge motion. Judge Kite came back and issued a statement on that, an order. And well, first of all, because of what Detective Johns did at that hearing on September 8th of 2024, the defendant's motion here was for the transcripts of Detective Christopher Johns' grand jury testimony. So again, in Florida, how it works, as you can see, we'll read this. Comes now the defendant, Shanna Gardner, by and through her undersigned counsel, and respectfully requests this honorable court enter an order to unseal and permit the defendant to obtain the transcript of the grand jury testimony of Detective Christopher Johns, the lead detective in this case, and as grounds, therefore, would state as follows. Number one, Miss Gardner charged. Oops, let me make this a little clearer. There we go. Ms. Gardner charged by indictment with murder in the first degree, conspiracy to commit murder, solicitation to commit a capital felony, and child abuse. The state has given its notice that it seeks the death penalty. There has been extensive litigation in this case. This litigation has revealed several false statements and material misrepresentations of evidence by Detective Johns. This includes representations that the evidence demonstrates the following. Miss Gardner knew that Mr. Tennant owned a blue Ford truck prior to his August 18th, 2022 arrest. So he claimed that when he was testifying. Okay. There's no way that she could have possibly known that. Okay. Unless she was involved with Henry Tennant. Well, that's not true. And in the hearing, they show how Detective Johns, didn't you go and tell Jeremy Ordway, they're going to call him J.O., didn't you tell him that Henry's truck was used in the commission of the murder of Jared Bridegan? And they have the actual police report that was written up, and that's exactly what happened. And J.O. is a tenant of Mario Saldana. And so what do you think J.O. went and did? He told Mario Saldana what the police told him. Okay. And so therefore, Jose Baez showing the courts that Detective John's statements that led him down to say this is a fact is absolutely unbelievable, because in his own police report, because he testified that nobody could have known that. The only way that Shanna would have known that and known about the vehicle, blah, 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 is because of her involvement. Her involvement in the murder. Absolutely wild. So Jose Baez had literally the way that this all played out too. I felt like the defense was not prepared for the Arthur hearing. And now I know why. Because I finally got my hands on all of the motions, everything. The way that it was scheduled is that Judge Kite said, here, we're going to wait until the motion, because they try to disqualify the Fourth Circuit team, the district attorney, from being able to prosecute this case because of the whole big taint issue. They were basically in digitals that they shouldn't have been in and looking, and they didn't do the taint team right. They said that they were going to use this Secret Service. They didn't. It was a wild mess. And Judge sided basically with the defense and said, yeah, I cannot believe Stifler. What the hell did you do here? Okay. Because the taint team would have been needed from day one when you were obtaining the devices of Mario Saldana and Shanna Gardner, because they have privilege between themselves, but also there's privilege with their attorneys. And just because they weren't arrested for however long, they most certainly both had attorneys, and they most certainly were both talking to their attorneys, and they were trying to cooperate with law enforcement. So none of that happened, though. It happened in a really weird way. Let's just put it that way. So when Jose Baez put in the motion to have the Arthur hearing, okay, because they were trying to get bond for Shanna Gardner, because the district attorney's office, they knew that Shanna Gardner should have made bail, and they were planning on her to make bail because they were in communication with the defense team. They're talking back and forth, and they know that she's probably going to be given bail. Yeah, something's going to be set for bail. Because literally Shanna Gardner was arrested solely off of how Detective Johns and his version of how he put everything together. His version of events versus actual evidence. Because it's kind of like the Donna Adelson case in a way where you're going for Donna Adelson. She wasn't at the crime scene, you know what I mean? She's this mastermind, right? So, and it's how you're going to interpret and put all these things together to try to say that, like in Donna Adelson's case, Donna Adelson's writing these checks. Okay. In Shanna Gardner's case, to say that Shanna Gardner's account was funding an account that Mario had and blah, blah, blah. Okay. Well, the difference is Shanna Gardner and Mario are married. It's a big difference. Okay. So, but anyways, when Judge Kite made her decision that she comes out with her order and she wasn't disqualifying. Okay. She basically admonished and reamed them, but she was not going to disqualify the prosecutors from prosecuting this case and giving it to somebody else to prosecute. She then sets the bond hearing for literally 2 days after she gives that order. It's like, okay, boom, now we're going to have, and just literally sets the dates, and it's in 2 days. And I didn't know that until going and reading through all of these documents. I was like, oh my God. I was like, this makes so much sense. Cause I was like, I've never seen Jose Baez not prepared. And I thought he was not prepared. And he still was able to juggle it. Now going back in that 7-8 hour hearing and watching Jose Baez perform, if you now know that you're told that you have that hearing in 2 days. Now, Judge Kite said he could have asked for a continuance and it would have been granted, because what Jose Baez argued in the motion was Susan Lee wasn't even on the witness list back when we got our discovery. Like, her name wasn't even on there. Okay. We hear about Susan Lee the day before the bond hearing. And Judge Kite's like, well, you could have asked for a continuance and blah, blah, blah. And in Jose Baez's defense, he's like, well, I have this guy on lies. I mean, how are we not going to get this? Like, we're going to be able to show that the detective is lying. But imagine this is not only did he have him on just little lies, if he actually would have had that continuation and was able to talk to Susan Lee prior to, he's on the stand saying that he talked to Susan Lee, or that he never talked to Susan Lee because she changed her phone number. Here, Susan Lee is watching that trial or that hearing, and she's like, what? I've had the same phone number since 2013. What is this man talking about? That's insanity. And she's like, and I talked to him, and I've talked to this man. And I was over here thinking, holy shit, like, Judge Kite's gonna have to like do something about this. And I mean, the littlest thing I thought would happen is Shanna Gardner would be granted a bail. Okay. So, let me pull up one thing. Okay. 11:14. Okay. So, back in November of 2023, the way that you have to do this is you have to be super specific in Florida. If you want the grand jury, it's very secretive in Florida. Like, so here you're basically going for certain people's testimony. And so back in 2023, right there at the end on 11/14, Shanna Gardner files in the defendant's unopposed motion for transcript of grand jury testimony, and it's for KJ. Okay. And Judge Kite gave, it was unopposed by the state. And so you can go ahead and have that. Okay. So they get that. Then they show in court that Detective Johns is over here giving out subpoenas, out-of-state subpoenas. Okay, a sworn statement subpoena for Linda Luchetti. These are illegal. You can't do that. He doesn't have that capability. And so Jose Baez uses that at the bail hearing. This is when Shanna Gardner was asking for the discovery with the taint team, demand for specific discovery. So this was at the tail end of 2023. And this is when they started realizing that a lot of shit's fucked up in this case. So Shanna Gardner was asking for the names, positions, employing agencies, and contact information for the members of the taint team used by the Office of the State of Attorney to remove privileged information from devices seized from Ms. Gardner. The protocol used by or any guidance, informal or formal, provided to the taint team to perform the review. And this is where they find out that Sugar Tits Stifler totally lied. Fucking lied. And said that she used the Secret Service. And said that she used people that knew what they were doing. And guess what Jose Baez does? He deposes these motherfuckers. And they've never done taint in their life. Oh, like what? Wild shit, right? Okay. So the first big order came down, and again, this is when Jose Baez puts in a big motion to disqualify Stifler's and Nelson. Nelson runs it to prosecute this case. This needs to go to somebody else. All right. And so here's just the order denying it. And this order comes down on May 13th of 2024. And she, when I say she, Judge Kite, I want to show you some very specific points. He impeached. Let's see where she goes ham. So Kite says, However, defendant Fernandez and defendant Gardner hired counsel pre-arrest and pre-indictment. They were active in communicating with their attorneys while the homicide investigation was ongoing. Both defense teams notified the state about the danger of examining the evidence like other homicide cases. The defense teams were diligent in their efforts to safeguard privileged information. They suggested using a taint procedure overseen by the court to protect privileged information. Dude, they did this during the investigation. Like, they had their lawyers immediately go and they say, like, listen, we know what you guys are going to be doing. You're going to be getting search warrants, subpoenas, and all this shit. You need to be very careful here. Okay, because, and so wanted them to get a taint team back in 2022 during this investigation. They suggested using a taint procedure overseen by the court to protect privileged information. The state assured the defense and the court that sanitized law enforcement agents would conduct the taint review. Simply, that did not happen. That is the conclusion of Judge Kite. Okay, simply that did not happen. The footnote states that the court believed both sides would work together. Again, that did not happen. The state and the defense are not required to work together to solve issues. However, it is incumbent upon the prosecutors to govern themselves above the conduct of other lawyers. Knowing that this case presented a unique set of circumstances, the state took an understaffed, ill-advised, and hyper-technical approach to the agreement to use a taint team. Listen to this. The court recognizes that while the state attorney's office may have had good intentions, the ultimate execution of this procedure resulted in the situation presented to the court. When law enforcement realized that there may be missing information on the devices, they secured search warrants on the internet-based storage accounts of both defendants. So they determined in their minds that, hey, there's deleted stuff, there's missing stuff. I think we could probably go get that stuff if we go and get like iCloud type shit. Okay? And so listen to Stifler. This is how Stifler operates. Hey, our agreement was that we'll use a taint team on the search warrants for the devices. We never said that we would use a taint team for iCloud stuff. You fucking bitch. Are you kidding me? Like, that's how she presented it, that she should get away with this. And Judge Kite said, abso-fucking-lutely not. This is wild to me. The returns for the search warrants were given directly to investigators for review. No taint team for like, right there, your internet-based storage accounts. While attorney-client privilege information certainly would exist in an email folder, this is a narrow and dangerous view to take when the state gathered multiple terabits of electronic data from the defendants. In 2024, attorneys can use many ways to communicate with their clients, because that's what they were saying. We didn't just do email. It's 2022, 2023, 2024. People use all different types of ways to talk and communicate. So the defense attorneys can request and facilitate their clients to create many different forms of information that the privilege may cover. And in this case, these attorneys were like, you need to start doing timelines. You need to start keeping track of everything. Okay. And wanted them to document shit. So, the investigators did not contact the taint agent, and she did not have independent legal support. Inevitably, this resulted in the prosecutors conducting their own taint review for the taint agent and the investigator. What? You can't. The taint team goes through. They go through the shit. And fucking they're doing their own taint. The state argued that the agreement was only related to the devices. Can you believe that she made that argument? I'm dead that she made the argument. That's some balls, Stifler. The court rejects this assertion. Thank you, Judge Kite. You want to know if it was Hitler? Hitler would have been like, yep. Technically, yep. Sounds good. No, Judge Cart was like, what? When the state failed to extend the agreement to the internet-based storage and the defendants did not know that the state was seeking this data, this foreclosed the defense from seeking court intervention as they did on the devices when they were notified of the seizure. It's common sense, Judge Kite says. God, I love it. It's common sense and prudent that the agreement should have extended to the information on internet-based storage accounts. This digital data was a natural extension of what was on the seized devices, and was sought partly because it may have had copies of the data deleted from the seized devices. Exactly. This is common sense. And Judge Kite says it. The state's approach to the agreement resulted in the high probability that prosecutors and investigators would have access to a client-attorney privilege information. As one could have predicted, not following the agreement and giving unredacted copies of the data to ATF Butler, seeing unredacted communications, and other law enforcement before the taint agent completed his filter review quickly led to ATF Butler seeing unredacted communications. ATF Butler's avoidance of the contents of the email and email contents folder being the only care taken to prevent seeing privileged information was naive. Considering how internet-based storage services are used for both the creation, storage, and transmittal of data, attorney-client privilege information could have been and was contained in other storage areas. Upon being notified by ATF Butler that there were two potentially privileged documents she found in defendant Fernandez's internet-based storage, Assistant ASA Stifler could have immediately shut down her review. Could have. The court is confounded as to why ASA Stifler did not act similarly as she did in defendant Gardner's case. Instead, ASA Stifler took the risk of determining whether the documents were privileged or not. She's a sick, sick puppy. To do this, ASA Stifler needed ATF Butler to reveal the contents to her because no taint attorney was assigned. Well, tell me what it is, and I'll tell you if it's client attorney privilege. Dude, what? You guys, you know I'm going to go off on this type of shit. This is wild. Wild. Hey, just tell me what it is, and I'll tell you if it's priv or not. Okay, girl? Oh, boy. By the way, Jose Baez, they deposed Stifler. Okay. I mean, not Stifler. They deposed Butler. They deposed Navarez. It's going to be sick what's going to come out in trial. Their asses are just so grass, man. If this is what this, and this is Judge Kite. This is what's so great about this. So, if ASA Stifler was correct in her thought process that these documents were not privileged, then she would have obtained new, possibly relevant evidence. If ASA Stifler was incorrect, she could not unring the bell of her learning privilege information. ASA Stifler admitted she chose this path instead of sending the documents to Agent Nazario. She was on the stand and had to testify to this. Okay, so I'm just I'm bringing us back and reminding us all just the fuckerage around this case. And people just think it's like this slam dunk. It's anything but a slam dunk. It's the last thing from a slam dunk as far as Shanna Gardner's case is concerned. So this assistant prosecutor right here was like, yeah, man, I admitted to it. Yep. I did this instead of contacting Nazario because she knew this content blind review would remove both documents from the filtered return. She knew that she wouldn't be able to get it, determining if the content was privileged. Again, ill-advised. Again, just ill-advised. Had the state allowed the court intervention, the setup, appointment, and oversight of the taint review, the question information could have been reviewed by the taint agent and identified for the defense as questionable information. If the defense wanted to restrict its disclosure to the prosecution based on a privilege claim, then the court could review it and then rule on it. There would not be a fear of potentially relevant information being quote unquote deleted because of the heightened level of content blind review that the state agreed would be the operating procedure. The accidental upload of the original files. Okay, so then this is what happens next. This is how just blasé. She's just so la-di-da blasé. Or, and I love it because I'm going to start doing that. I am just going to call people blasé. And it's like, and then the judge can then make the determination if no, they're really not being blasé, they are fucking corrupt. Or they know what they're doing. So then after this happens, then Shanna Gardner's attorneys and Mario Saldana's attorneys, when they're supposed to be getting them cross information, like after the taint team would technically review the material and then here, okay, now you get whatever the discovery is that we were tainting, that we were going through. So here, since that didn't happen, there's, or since it, after it happens, there's going to be a redacted version. Okay. And then before it happens, there's this unredacted version. Then this dipshit, Stifler, uploads the unredacted versions to both squads. Here's all the communication from this person's phone you get, and then you get, and it's not supposed to be that way. It's supposed to be redacted because the defendants, they don't get the other person's stuff either, you know? No. And then so the accidental upload of the original files to the next point, that's like evidence.com type, like that's how you're using it to view discovery. It's called next point. This is what led to the case being pushed back a whole year because the prosecution doesn't know how to do discovery. The accidental upload of the original files to the next point portal and the state's response show that this was not the substantial misconduct of prosecutors warranting disqualification. That's the only reason that they stayed and were not disqualified. To the state's credit, once it was alerted that the unredacted originals of the data were uploaded to Next Point, which was a week later, and viewable by everyone, orders were immediately sent out to restrict all access. To her credit, individually, ASA Stifler also contacted the attorneys for defendant Gardner to inform them of the issue. There is no evidence that anyone at the state attorney's office accessed any privileged information via Next Point. And it's like, how are we supposed to have that evidence? How can we possibly have that evidence unless you're going to give us, hey, well, we need to see the forensic side of all these computers because then we'll be able to tell. And that's why they called people to the stand. So anyways, long story short, the evidence has shown, though, that the defendant Fernandez and defendant Gardner seek extraordinary remedies for the states violating an agreement between the parties. The court finds that the agreement was violated in a considerable way. So guess what happens? And actually, it's a huge blow to the state because I didn't go back and didn't have these at the time. They're not going to disqualify. Disqualification is not a remedy for poor judgment. So she says that they had poor judgment, and instead, I think it's worse. Is I just want to read this though. I want to show how Stifler was admonished. After carefully considering the case law, evidence, and arguments of counsel, the court does not believe there was the level of substantial misconduct necessary to warrant the disqualification of an individual ASA or the Office of State Attorney for the Fourth Judicial Court. It is clear from the testimony of Stifler that she realized that they had agreed to a filter standard that was much more stringent than necessary. She took a poorly thought through chance in interacting with ATF Butler and Agent Nazario. The prosecution team limited the scope of the taint review, which led to law enforcement contacted to the case and to investigate capacity seeking potential privileged information. There was no evidence of nefarious conduct by the prosecutors. Instead, the court finds that ASA Stifler, she was just so naively thought she could prevent law enforcement's exposure to privileged information by them to avoid email folders. This amounts to poor judgment and not substantial misconduct. ASA Stifler minimized the lapses of judgment. There is no evidence that the alleged misconduct is attributed to any other ASA in the Fourth Judicial Circuit. She says it was just a lapse in judgment. Okay. So then she continues and says, but guess what? You're not going to get kicked off the case, but there's a big problem for y'all because those text messages that y'all wanted and y'all were planning on using, they're suppressed. She suppressed the evidence. And the only way they can come in is if Mario Saldana opens up the door. So, yeah. So I can just tell you that if it was in Hippler's court, that wouldn't have happened. But she suppressed all that shit. Now, okay. Now, just like, because this is a capital case, I just want you guys to know that Shanna Gardner's team has been filing a ton of motions because it's a capital case, just like how Ann Taylor had to. It's just not getting the type of coverage, okay? So I, though, printed them off. I mean, one of the motions is 303 pages, one of them 56 pages, 26 pages. But I just wanted to show you guys for the record to say, like, oh, Ann Taylor's being all like, blah, blah, blah. No. This is what you do. Okay. So defendant's motion to declare prior violent felony language in section of Florida statutes unconstitutional for vagueness. So like they're over here saying that the vagueness for a capital case, and they're doing everything that Ann Taylor was doing. Another one is motion to declare section 921.141 Florida statutes unconstitutional due to failure by a legislator to narrowly class of death eligible murders. This is going to win. Defendant's motion to prohibit all use of the word recommendation to describe the jury's role in penalty phase. Because it's so true. You're not giving a recommendation. In Florida, it's 8-4. If you can get an 8-4 verdict, if you get 8 people to say that you should get the death penalty, that's what happens. So this isn't a recommendation. So when you're giving, like, however you're going to vote for the penalty phase, and so Jose Baez's team was like, we want the words recommendation taken out of any jury instructions because this is not a recommendation. It's not unanimous in Florida. No. The statute uses the term recommendation. I read this, and this is really, really interesting to me. The statute uses the term recommendation 7 different times. And it's like, how are you lying to these jurors that what their recommendation is? No, it's their vote. Okay. And look at how he puts up this motion. And he writes, for obvious reasons, jurors rightly view judges as more experienced and better equipped to make the life or death sentencing decision. Using the term recommendation invites jurors to pass the buck to the learned judge, leaving jurors with the impression that they only make a recommendation provides the way out for jurors to avoid the awesome responsibility for a decision to sentence a fellow human being to death. I just love the way that was formed. Yeah, the awesome responsibility. Basically they're mocking that. Like, how should any citizen have that responsibility? Okay. So after all this fuckerage was going down, well, we'll come back to that part. Okay. Check this out. Well, let's go back to this. I thought for sure Judge Kite was going to grant this. So the defendant, Shanna Gardner, was like, I need Detective Christopher Johns' grand jury, just like how she wanted KJ's. Okay. And so she lists these reasons. There has been extensive litigation in this case. So I already said that. So here, Miss Gardner knew that Mr. Tennant owned a blue Ford truck prior to August 18th. That Detective Johns did not speak to SL. The omission of the use of LOL in certain text messages discussing Jared Bridegan that they put and used as exhibits at the hearing. They fucking fabricated evidence. That is fabricating if you do not use the whole sentence. And at the end of these, LOLs. What the hell's going on? How what? The representation of bank transfers from 2021 that were totally unrelated to the 2022 checks written to Mr. Tennant. And that Linda Luccietti was running and hiding from him. Okay. Miss Gardner has cause to believe that the testimony given by Detective Johns, upon which the indictment is primarily based, contains material misrepresentations and or knowing false statements that may have fatally infected the grand jury, depriving her of her constitutional rights to due process pursuant to the Fifth Amendment. Legal standard in Florida, so it's a little bit different here in order to be able to get grand jury testimony. Both the laws of the state of Florida and the due process clause of the Fifth Amendment are instructive for our argument. The state of Florida provides for a list of exceptions to the general rule concerning, I have to make this bigger, concerning grand jury secrecy and the Federal Circuit jurisprudence on the due process implications of grand jury secrecy. So here it is, these three. Florida statute creates certain exceptions. Ascertaining whether it is consistent with the testimony given by the witness before the court, determining whether the witness is guilty of perjury, furthering justice, which can encompass furthering a public interest when the disclosure is requested pursuant to paragraph 2C. Florida courts have repeatedly upheld the standard, and so that's what in Anderson in Florida, the Supreme Court of Florida incorporated the Ninth Circuit's understanding of the guarantees to constitutional due process with respect to grand jury secrecy. Due process is violated if a prosecutor permits a defendant to be tried upon an indictment which he or she knows is based on perjured material testimony without informing the court, opposing counsel, and the grand jury. And so Shanna Gardner's team is like, they knew this was false. They knew what he was saying when they elicited this testimony. It was false. And they made the exhibits themselves, and they knew that the LOL was taken out. Florida courts have repeatedly upheld the standard, C being verse state. Due process is implicated when a prosecutor permits a defendant to be tried upon an indictment which he or she knows is based on perjured material testimony without informing the court opposing. So it's like, this is the same thing. This is the same thing as the federal. In conjunction with Florida's statutory exceptions to the rule requiring grand jury secrecy, the 11th Circuit adopted the quote unquote, the compelling and particular need standard for seeking disclosure of grand jury testimony and the related tripartite test for achieving that. Whoops. Parties must show that they have a compelling and particular need for the grand jury material in order to avoid an injustice, and that their need for disclosure outweighs the secrecy needed. I would be saying it's because we didn't get our Shanna Gardner would have made bail, right? The way that Judge Kite takes this is like, you want the grand jury you want the grand jury testimony for the future, and it's like, wait, what? Obviously we can use it in the future, but no, we need it now because my client could be out and not in behind bars. So hold on one second. Miss Gardner has ample grounds to assert, based on Detective Johns' testimony and the state's PowerPoint at the Arthur hearing, that the state of Florida obtained an indictment against Miss Gardner that it knew was based, at least in part, on perjured material testimony in violation of Miss Gardner's constitutional rights. The prosecution's Arthur hearing presentation exposed numerous inconsistencies in Detective Johns' testimony, upon which the indictment was at least partly based. Number 11 is Miss Gardner asserts that the state would not have obtained an indictment without the perjured material testimony and intends to challenge her indictment. The Arthur hearing exposed numerous inconsistencies and fallacies in Detective Johns' testimony. Detective Johns alleged that the only way that anyone, namely Miss Gardner, other than those involved in the murder, would have known about Henry Tennant's involvement and his blue truck's involvement in the murder is being involved in the murder. This is squarely contradicted by Detective Lamont's report detailing how the police informed Tennant's roommate that his truck was used in the murder on August 18th, 2022. And Tennant's roommate contacted Maria Fernandez, who thereafter contacted Miss Gardner. Additionally, during the Arthur hearing, the prosecution deceitfully used bank records from 2021 to establish a financial connection between Miss Gardner and Tennant, despite the murder having occurred in 2022. They presented these March and April 2021 records to the court, fully aware that Jared Brightingham was killed by Tennant nearly a year later. Everybody and their mother thought that those were 2022 transactions. I thought that those were transactions that occurred right after the killing and that he's paying him on the back end. That's how it was presented to me. But really, those were checks cut in 2021, almost a whole year before the murder, where Mario Saldana had him as a tenant, but also he did odd jobs for him. Again, during the Arthur hearing, the prosecution removed and Detective Johns omitted the phrase LOL when presenting to the court the years-old hitman text messages between SL and KJ. The LOL clearly showed the content of those messages was not meant to be taken seriously. Detective Johns also testified that he was unable to locate and did not speak to Miss Lee, which we now know is false. So our request is compliant with the legal standard for producing grand jury testimony in the pursuit of justice. You remember that, Heather? I was blown away. Absolutely blown away. And that actually helped the state here. They had this hearing within 2 days. No time to prepare. The defense had no time to prepare. Yes. Should they sort of said, hey, we need a continuation? Like, what's going on here? Like, and we didn't even know Susan Lee was on. Like, I got that stuff a day beforehand. There's no time to prep for that. So this gets put in, and I'm like, dude, this is totally getting, like, how could you not be able to get this man's, oh, here we go. There's more. I'm just like, how are you not going to get the grand jury, you know? And clearly the prosecution was opposed to this. They're not like, yeah, you can just have it. Like, we have nothing to hide. Okay, so here, the testimony given by Detective Johns and representations by the state at the Arthur hearing demonstrates that Detective Johns' grand jury testimony must have been false in material manners, because it's common sense that that's how he would have testified at the grand jury, right? If we're having a hearing so that my client could get out on bail, right? You're testifying to why she shouldn't, and you got to believe that was stuff that was testified to at the grand jury, right? There are a number of interests at stake that would justify the production of his grand jury testimony. Chief among them, the need to preserve Shanna Gardner's due process rights against being tried upon an indictment which contains perjured testimony. A police officer does not share the same social expectations of privacy and secrecy that a lay witness subpoenaed before the grand jury is entitled to. See Waite v. State. Holding that in the context of surreptitiously recordings, law enforcement performing official duties are not entitled to a reasonable expectation of privacy. Miss Gardner's request is limited in scope and only seeks the grand jury testimony from Detective Johns. Miss Gardner requires the grand jury testimony of Detective Johns to ascertain whether his grand jury testimony is consistent with the testimony he gave before the court, to determine if he misled the grand jury or is guilty of perjury, and to further justice and a public interest. So this was all about the grand jury. Okay. He's already testified at the grand jury. Now he testified here at the bond hearing. And if he testified the same way that he testified here at the bond hearing at the grand jury, we have a huge problem, right? That's what I would think. Well, I want you to take a look at something. I want you to take a look at these dates. Well, in conclusion, to be clear, this is not a fishing expedition, he says, or a request based on speculation. Detective John's testimony and the state of Florida's PowerPoint demonstrate the proper predicate. The LOLs removed. How do you not get it off of that? No one else is covering this case because MSM is reporting it like any other. Yeah. Yeah. And I cannot believe they're not. This case is interesting as fuck. This request for Detective Johns' grand jury testimony satisfies the state of Florida's statutory exceptions and constitutes a compelling and particular need in accordance with the constitutional due process consideration. Ms. Gardner needs this testimony to avoid the constitutional harm of being tried on an indictment based on perjured material testimony. So this is nothing in the future. Okay. This is to show that she was indicted on perjured testimony. Hello. Okay. So this was dated and filed September 8th of 2024. Okay. Well, it about blew my mind when I saw that an order didn't come until January 8th of 2025. What? You guys, what? Order denying defendant's motion for transcript of Detective Christopher Johns' grand jury testimony. She had it all September, October, November, December. 4 months. You want, how does it take, why would it take her 4 months to make this ruling? Order denying defendant's motion for transcript of Detective Christopher Johns' grand jury testimony. And I'm like, whoa, how? This cause came before the court on defendant's motion for transcript of Detective Christopher Johns' grand jury testimony filed on September 8th, 2024. In defendant's motion, she requested the court unseal and provide her with Detective Johns' grand jury testimony. Under Section 905.27, the disclosure of grand jury testimony is not permitted except under 3 limited circumstances. And we just talked about those. Now, she says a different case here. Gosimiski versus State. In applying this provision, there is no pretrial right to inspect grand jury testimony as an aid in preparing one's defense. What? And holding an in-camera inspection of such testimony is a matter within the trial court's discretion. That's where I couldn't believe that she's citing that case. Wait, what? This isn't for... How is this aiding in the preparation in one's defense? This is something that deals with something that already happened, in my opinion. Of course, anything that also happens in the past is always going to, in some capacity, prepare you for the future. So I just think that this is wild. In order to obtain access to such testimony, a proper predicate must be laid. Mere surmise or speculation regarding possible inconsistencies in testimony is not a proper predicate. I can't believe that. What do you mean a mere surmise or speculation? So then they cite this other case. And so basically what Judge Kite is saying that the defendant is, we're speculating. What are you talking about? We're not speculating on anything. This was his testimony in your courtroom during the bond hearing, the Arthur hearing. Okay. The LOL was removed. That's a fact. The 2021 checks were played off like they were 2022 checks. That's a fact. He lied about ever talking to Susan Lee. That's a fact. Next, defendant seeks disclosure of Detective Johns' testimony because she believes he committed perjury in his testimony to the grand jury. No, what she believes is that if he said these things that he said in this courtroom at the grand jury, then it's perjury. So there would have to be a ruling, in my opinion. This is common sense. And this is where Judge Kite, in my opinion, why aren't we applying the same common sense that you just applied in suppressing those text messages for Mario Saldana? Like, it's common sense. So the defendant cites 5 examples from her Arthur hearing, 3 statements by Detective Johns, and 2 evidence exhibits that she claims are false testimony and material misrepresentations. But what are you determine? What are you like? Yes. So what's your determination of that? She argues that these examples were likely presented to the grand jury, and thus the state knowingly presented false testimony to the grand jury. All of defendant's examples, however, are the exact types of inconsistent statements between witnesses or different interpretations of evidence that fail to meet the burden of creating the proper predicate for disclosure. I completely disagree. And this should have been objected to. This should have been appealed. What do you mean? inconsistencies. What the fuck are you talking about? We don't know if they're inconsistent because we don't know what the fucking grand jury testimony says. The fuck? And his interpretation of the evidence, his interpretation of the LOL, you can't just take that off. There's no misinterpretation. How is that? What? I was blown away by this answer here. Just blown away. How about you in camera review it? All of defendants' examples, however, are the exact types of inconsistent statements between witnesses or different interpretations of evidence that fail to meet the burden of creating the proper predicate for disclosure. Defendant's argument requires the court to assign credibility to her witnesses and interpretation of evidence while wholly discounting that of the state. What the fuck are you talking about? No, it's to look at the text messages and see, was the LOL not put up on the board? And if they're not put up on the board, then it's 100%. 100%. You're fabricating fucking an exhibit. Give me a break. Now, if he wants to testify to what he interprets the LOL, sounds great. But at the grand jury, there wasn't somebody to poke holes the way that Jose Baez was poking holes. What the fuck? What the fuck? And all of this stuff wasn't caught at the bail hearing. It was all caught, most of it after the fact, okay? And then having to put in a motion about that. And so I'm just blown away. You know, I'm blown away because it's not about the credibility of something here, in my opinion. It's about Detective Johns testified at the grand jury. Seeing this in the way that it was presented in front of me, it gives me pause. Okay. I'm not going on a fishing expedition. It gives me pause that, yes, if you testified in this manner at the grand jury, we have problems. This is called protection. So guess when Shanna Gardner can bring this all up? What, on an appeal? Like down the road to show that when we get the grant, I mean, there's no fishing expedition here. They kept the LOLs off. That should be good enough. But she just says that at this point in the case, there is insufficient corroborating evidence to support defendant's theory that any of these inconsistent claims or evidence are anything more than different accounts of events, much less knowingly presented false testimony. And I just completely disagree. So, but that was the ruling. But don't worry, Jose Baez deposed his ass. In fact, let's talk about that. The deposition so far in this case. Jose Baez's team deposed the taint peeps. Okay. Angel, God, I was thinking about, Dexter. Isn't that just crazy? Nazario and Lindsay Butler deposed. Boom. Defendant's second notices of taking depositions. These people right here, Tony, CF, Aaron, Ryan, these people right here, they were they ended up being deposed, but these are all ear or civilian witnesses. Next, Thomas, Brian, all these people right here, same thing. These are either people that gave surveillance camera. They were interviewed as civilian ear eyewitnesses or gave camera footage from the area. That next grouping right here. Next, defendant's third notice. Then we start getting into law enforcement, and I actually have the dates of these, so hold on. All right, these are the officers. So they did their first batch of officers was Friday, June 21st, 2024. And it was Jacksonville Beach Police, people that were first on scene to do the crime scene. Then October 10th of 2024 was another round of Category C witnesses, which were surveillance witnesses. On November 13th of 2024, again, these were people in the area that Jose Baez questioned basically the version of events given by the state. You could tell when looking at the discovery. That's what I noticed. Again, November 14th, 2024, those are civilian witnesses. Now, November 21st, 2024, we have people that are their addresses aren't listed. They were Zoom, and they want everything to go through the state attorney's office. So it's interesting with that. December 11th, 2024, Janie Deal was deposed. That's Henry Tennant's lady friend that was with him that day. That he was in the car. January 9th, 2025, Detective Jarman, Officer Aaron Filbert, Property Officer James Choat. January 24th, Christina Williams. Again, these people would just be civilians. Now, March 26, 2025, big boy Detective Christopher Johns had his deposition, and I'm sure he was in there for fucking the whole goddamn day because they only scheduled him on that day. Okay. And so they've gone in a very interesting order of their depositions. Then where is, oh yeah, right here. I think he's waiting for, and then just this past summer, Special Agent Mutz from the ATF. Depoed again was Aaron Filbert. Two more people were depoed again that were already deposed. And I think he's waiting for a very special occasion to do a couple people, which would be Detective Young, Lamont, and Burrell. Those are going to be good. So anyways, he's on it. As far as like they're doing, I mean, they have a really good team though. They're stacked. Okay, so Discovery. Check this out. I thought, well, it's very organized in terms of like, it looked like, here you go, you're getting everything. It's a lot. It seems like, okay, they have everything organized. There's not going to be an issue with Discovery. I printed all that stuff out. If you go back and you check out my channel, you can see all the different police reports. You go over every single one of them that were given publicly. So what this is this is all the Discovery that was issued. Okay. Your first disclosure. And then after that, it would be like supplemental 1, just like how Ann Taylor was asking for things. So when we get into the state's first supplemental discovery, I'm able to see based on what they're giving. So we've already went through the first. So this is, or the initial dump. Here's the first, and there's 7 of them. And category A, it's like those witnesses that would be a civilian. Now we have computer forensic investigative unit. And so they're listing those people. Now for the first time, Agent AJ Nazario was put on. And so that's why they didn't even know about him until June 20th, 2024. The 911 calls, they didn't get the 911 calls in their initial. So Shanna Gardner was arrested November of 2023. She's getting the 911 calls almost a year later. Written statements previously provided and listed as physical exhibits, witness statements, the recorded interviews. And so of these people, which they weren't in, obviously, or they were listed. And then when you're going to look for them, they're not attached. So then you have to say, hey, we have the report, but we don't have the recorded interview. So as you can see, it's all about recorded interviews. And that tells me that's exactly what happened there is they go through the police reports and they're saying, and so what they're doing is they're making a list here. This is what, like, you gave me this police report. You said this was attached. It's not. I want to listen. I don't need your report of it because you guys can't write reports for shit. So as you can see right here, recorded audio. Then right here it says response to defense inquiry. No recorded interviews exist for the wife of Jared Bridigan. Now I find that hard to believe. I can't believe that when a husband is usually killed. I mean, yes, ex-husbands or wives are first people that you look at, but also your current wife is somebody that you would look at. So here to see this in writing, which is there are no recorded interviews that exist with Jared's wife. There are no recorded interviews with Linda Luccietti. Linda Luccietti, okay, is over here saying, I wasn't hiding from fucking Detective Johns. Just wild shit, everything that they would need. Oh, wait, there's no, we didn't record that. What? Additional statements of the accused as relayed to the state August. This is by KJ. Look at this. So we get it as redacted. All right, so this has been in June of 2024. Remember, they brought in this Kim Jensen woman and enlisted her as a, hey, we're going to arrest you for murder if you don't tell us certain things. We asked for the grand jury. We were allowed to get it, and we still don't have it. iPhone Silver, Shanna Gardner, we don't have it. We don't have this iPhone 13 Pro SIM, the SIM. We don't have it. This is a year almost after the arrest of Shanna Gardner. All wire recordings previously provided. So they already gave, there's 230 wire recordings. 230. Search warrants and subpoena returns, they're missing, or the things that they're asking for here. Now, just to show you, we're going to fast forward. Okay. This is how thorough, when you're asking for stuff, then we're getting into Henry Tenen stuff, T-Mobile, Verizon, all these people's shit. I mean, it is so extensive. Okay. That was just the first round. Then the second supplemental discovery, July 26th. The third, 11/14/2024. Here we go. We find out who their experts are going to be. So Mark Sonendecker, he's the expert for the digital forensics, cellular record, and geolocation data analysis, cellular telephone tracking, and forensic examinations. He's out of Denver. What a shithole. Jeez. Jail phone calls, video tablets, jail mail, subpoenas, 3 provided to defense counsel, Lucietti, Thomas Colton, ATF cellular analysis slides. Then state's 4th supplemental discovery, Jacksonville Sheriff's Office incident report, Shanna Gardner disciplinary report dates. They say that Shanna Gardner these are her disciplinary dates. She was disciplined on April 29th, 2024, June 13th, 2024, June 15th, 2024, January 5th, 2025, January 5th, 2025. 2. Additional statements of the accused, Shanna Gardner. Marriage is really hard, like really hard. I should know with 2 failed marriages. From letter dated April 10th, 2024 to Cortini Reese. He reminds me of a Mario a little, which terrifies me. From letter dated April 10th, 2024 to Mallory. We all got a slap on the wrist, which is so much better than the 10 or 15-day DR we should have received. I'm feeling embarrassed. And this is where things start shifting. More and more Mario-like tendencies. From letter dated April 4th, 2024 to Sage Gardner. I see so much good in him. He is a damaged soul. You know me and my broken things. I could be very good for him, but it's like a Mario situation. He would have to be willing to work hard to heal himself, not want me to fix him. From letter dated April 4th, 2024 to Sage Gardner. What? Dude, are people trying to hook up Shanna Gardner in jail? Anyways, category B, 5th, this is on February 20th, 2025. 5th disclosures. The expert, they have a forensic science laboratory that they used in Washington. Remember, she lived in Washington. And then they asked for DNA bench notes and files. And so imagine that they have all of that. Look at, unlike in Idaho, you have DNA bench notes and files provided. Dude, this shit This is all discovery. These are all the requests. This is 2025. You're supposed to have like you're supposed to be going to trial in October of 2025, and this is still happening. Then a huge blow up happens where they have to put Alan Chipperfield, who's who's the hitman Tenon's lawyer, on the witness list. So he's listed on the witness list now. And his handwritten notes from January of 2025. Email correspondence related to Tenon's transport. And then State 7 supplementary just was in April of 2025. This is what Mario Fernandez, one additional letter disclosed for a total of 8 letters, 4 of which are incoming mail and 4 of which are outgoing mail. Shanna Gardner, 3 additional letters disclosed for a total of 17 letters, 8 of which are incoming and 9 of which are outgoing. Henry Tenon, 4 letters disclosed herein, 1 birthday card from ST, 2 money orders from DT, and 1 letter. Henry Tenon's getting money orders. Statements by Shanna Gardner and Shelley Gardner contained in emails and text messages, group recordings, wiretappings, transcripts. So they not only got the audio of all the transcripts, then somebody had to go through and do all the wiretapping transcripts. You know how long that takes? You know how much money that is? That shit is not cheap. That is very, really expensive. Body camera footage arrests of Henry Tenon. They are like, the media has his arrests in body cam, and we've never seen it. The defense. Surveillance videos previously listed provided via hard drive April 10th, 2025. Then, I mean, look at all this stuff. They said we need all the subpoenas, the returns of all these subpoenas. They scoured through everybody's finances to the point of like the signature cards, the written checks. I mean, look at all this shit. Overdraft records. Who's buying hits with overdraft? Okay. What the fuck's going on around here? And it's because, no, it's all these people like JRB. He's basically, in this case, they're going to try to say that this JRB dude, John Biggerstaff, he's a swinger. He's Mario's friend. They've known each other because of the military. And he's like a co-conspirator, but they don't have him indicted. He's not listed. And I have no idea what he's going to testify to because they don't have the murder weapon. Wouldn't you be asking Henry Tenon what he did with the murder weapon? Where's the murder weapon? The shooter confesses, and he doesn't. What gun did he use? What's he saying? What gun did he use? Where's the gun at? I have no idea. But they believe that it was this guy's gun, is what they believe. The state. Don't know if they still believe it. They went through all of these records for Beach Baked, records for First Choice Home Rentals, NFCU, Chase, you name, I mean, everything. Audio video lab report summarizing of work labeled enhanced properties completed by, now this is going to be interesting, all these enhanced videos and photos. They have somebody that they did like with the Delphi case to enhance all this shit. ATF lab reports. No processing completed. Cellular analysis survey team cast final report in color. Expert report of Agent Bobby Blith. Previously disclosed and listed November of 2024. 42 slides. Agent Balance had 100 and ridiculous numbers of slides. This guy has 42 slides. Yeah, I got the goods. Atlanta overdraft hits. I'm dead. Who's getting overdrafts? Jacksonville Police Department supplemental reports 162, 63, 64, 65. Oh my God. Remember I was telling you guys about this? I was like, dude, they're missing all these reports. I was like, here's the defense team. They're right on it. They're like, yeah, where are these reports? Cough them up. So Jacksonville Police do not give over these reports, okay, that were very important for 2 fucking years, over 2 years. This is all stuff that they just got. They're claiming that they got. Now wait till you see what Jose Baez's team says when they say, okay, we need to show you guys this is everything that you guys said that you gave us. There is nothing in these drop boxes. There is nothing attached. This shit isn't there. You provide us with like, here's the search warrant or here's the subpoena, and then we don't have the records with it. Like what came back. And so they just list all this shit. And so here, again, now this is why this case did not go to trial when it was supposed to go to trial. It wasn't going to trial even if the stuff was turned over. We don't even have the stuff yet. Because then the defense gets to have their own experts testing the shit and going through it. Media inquiries from Shanna. Q&A for Shanna RE media interviews. Shanna Gardner intake. Shanna and social media notes. Text from Kirsten to Shanna. Email correspondence from Shanna. Cat's out the bag email. What? You guys, this case is going to be insane. And there will not be a plea deal. I can promise you that. There is no plea deal here. Okay. There will be a trial. And there will be a phenomenal defense. Okay. It's not going to be like the Adelson case. All right. This is going to be a fucking knockdown. This is going to be brutal for the state. Because I think Shanna Gardner alone has close to 14 lawyers. I mean, I'm not kidding. They are, woo. Forward. This is just something from ABC 2020. Nancy Grace, news segments, a few quick questions, Instagram account, Kristen Ray notes, next steps, print interview prep session, story, today's update 510. What is this? Right? Everyone's like, what is this? Dude, Jose Baez was the person that first came out and ever used somebody from the internet to be like his digger. Being wild is one word for it. It's going to be insane. Emails to and from Shelly. Draft Q&A for media interviews. Got your message. Long and important. Team emails. Contribute ideas for Gardner family. What? Exclusive Shanna Gardner interview. Like, look, I have no idea, but wardrobe for Shanna. Hi from ABC 2020. Items needed for Shanna. Key message points. The Daily Beast. She was pissed at them. They put the kids' pictures out. Interview with Shanna Gardner. Text messages. Text. Instagram. Oh my God. Then we got people on. Oh God, that's right. Somebody's Snapchat has a photo of the crime scene. That's going to come into play. I was reading that. Snapchat. There it is. Email to defense on July 19th. You guys, 2024, you guys sat on that for how long? That's why those people were being deposed by Jose Baez's team. I was like, why is he so obsessed with wanting to depose these? They don't know anything. Then I realized, oh shit, they got Snapchat messages and Instagram messages, and something's up. Photograph 17 of the tire stains that were swabbed and processed by ATF for DNA. Okay. So, I mean, I could list all this stuff off for you, but it is the most detailed shit I've ever seen. Okay. Like, I mean, everything. Everything. Okay. And I thought, I was like, okay. Okay. Well, Jose's team comes in and they say, well, we're filing a joint motion to compel discovery. And because this is all the stuff that we don't have, they claim that they gave us all of this stuff. And they gave us an unredacted copy of ATF report, 250 pages. While this report is not listed in the state's discovery exhibits, the defense discovered a redacted copy of this report online. So they're like, we are seeking this unredacted report that's 250 pages. We just happened to find this, though, online. And I'm like, how, dude, do you know how much time this takes? That's why there's a team of like, it's an army working. Look at this redacted document was discovered by the defense on the following website. And I was like, what is this website? It's crimetimelines.com. Jared Bridegan investigation. Like, who made this? They didn't even know this existed, that there was a 250 page ATF report. The media didn't get it. They literally have no idea. They must have done one of those. You could pay a ton of money and you can do, it's like a dragon scan and you can like scan the internet. Jared Bridegan, everything Jared Bridegan. Everything Shanna Gardner. Everything, you know. But here they found this, and in it is a 250 page ATF report. And they're like, well, we didn't get this. This was online. But guess what? We want the unredacted copy. Love the red sticker at the bottom. You like that? I was like, damn. Then watch this. I'll be going next to my my current coverage, but you guys got to see this. Okay, look at what it says in these things. It says, like, for example, JSO computer forensic report for Jared Bridegan's Mac. We have a 6-page report, but need access to the computer contents. Like, that's great what your report says. We need the contents of the computer. We'll see what's in this bitch. Okay. Jacksonville Beach Police Department supplemental report 54 attachment. Photos of Volkswagen infotainment removed. And then footnote. This item was included in the defense's May 2024 request for outstanding discovery. On June 3rd, 2024, the state responded and indicated will be provided. We still don't have him. Okay. Like, look at how thorough this is. They're like, hey, we went through these pictures and it's titled as clothes taken from the garage of Henry Tennant's house. Bitch, we have 10 photos in this little whatever folder. 3 of them are of boots, 4 of bags, and 2 of swabs, and 1 of a door. No clothes. Where are the clothes? Like, the name of the attachment is photos of clothes taken from the garage. This, again, this was filed March 31st, 2025. Intrepid Christ Management Records. They're like, we need to know what this encompasses to know if we have it. What is this? They're like, Intrepid Crisis Management Records. Dude, that is So how do I want to say this? Everything I just showed you prior to me showing you now with the defense, that happened first. That happened in February of 2025. Then in March 31st of 2025, they go through every single piece that they've ever received from the prosecution, and they literally blow it all up and say, what the fuck are you talking about? What is this? Where is this? Then they say, like, okay, receipt, Ruby Tuesdays, Fernandez, when he was on his trip in North Carolina, we don't have that. Advanced data recovery authorization form, we do not have that. The chain of custody for the phone, we do not have. Chain of custody for Mario Saldana's phone, we do not have. Handwritten notes provided to Detective Lamont from whoever, we do not have. Received 18 David reports. Unsure whether others exist. It's not listed by the state. They received them, and now they're like, well, what are these? We want to know if there's more. Vehicle search consent. Need identifying information to confirm receipt. Signed rights form for John Biggerstaff. Do not have. Now, this is the subpoena breakdown. John Biggerstaff's subpoena for AT&T dated March 2nd, 2022. That's how early they were on to this dude, Biggerstaff, that they were subpoenaing his shit. Requesting records for December 1st of 2021 to March 1st of 2022, a whole year prior to. How did they get a subpoena for records for a whole year? And it says, we believe we have records response, but don't have corresponding subpoena. Exactly. They want to see the subpoena. They want to see what you guys put in the subpoena to obtain these records for a whole year prior to, for some John Biggerstaff, right? On a March 2nd. Like, that's really soon thereafter. John Biggerstaff subpoena to AT&T dated May 12, 2022. Because you have to remember, you have to keep putting in subpoenas if you want to keep getting the new information, which would be, here, let's get his records for his phone from then, March, April, and then up to May 12th. And this is not listed by the state. Missing subpoena and response. John Biggerstaff subpoena toll records. Need more identifying information to confirm receipt. John Biggerstaff toll records. Subpoena and response. Detective will follow up. Do not have any follow-up information or documentation. John Biggerstaff toll records. And then this item was included in the defense's May 2024 request for outstanding discovery. On June 3rd, 2024, the state responded and indicated such records will be provided. They asked for this in 2024. This is now March of 2025, and they still don't have this shit. He's basically an unindicted co-conspirator. John Biggerstaff subpoena to Capital One dated May 12th, requesting records January 1st, 2022 to April 30th, 2022. Missing subpoena in response. John Biggerstaff's number 50. I circled that because it was pretty interesting. John Biggerstaff's subpoena dated June 3rd, 2024 to appear and provide testimony on June 5th, 2024. Not listed by the state. Only have information contained in state's response to defendant's motion for sanctions due to continued discovery violations. That's where they coughed it up, that they had John Biggerstaff in and interviewing him, and they never disclosed it to the defense. And this is how when you have good people that keep their timeline straight, and hey, wait a second. Well, I'm sure if you had him in there for an interview, where's this recorded interview? Where are the notes? Dude, this is crazy. They were supposed to go to trial in October of 2025. This was in May of 2025. I'm sorry, March. They were asking for it March 31st of 2025. Then the state comes back and says, we want to take pictures of Shanna Gardner's tattoos in May of 2025. And then they drop the bomb on the state. This is your big moment here. Boom. Defendant's motion for court order to obtain Jailhouse Informants communications. And I was like, hell yeah. May 23rd, 2025, because literally on May 7th, they put out a motion, the state, we want to take pictures of Shanna Gardner's tattoos. And I'm like, didn't you guys do all that? Didn't you guys do all that when, you book somebody? So basically what that means is they're probably going to try to show that she's gotten tattoos since she's been in there. Okay. The defendant's motion for court order to obtain Jailhouse informant communications. The defendant, Shanna Gardner, by and through her undersigned counsel, respectfully moves this honorable court for an order compelling the Jacksonville Sheriff's Office to produce jail communications, inmate mail, recorded jail calls, and tablet data, text, videos, you name it, in its possession or the possession of its agents for certain jailhouse informants that the state of Florida intends to have testify against Miss Gardner. Dude. In support of this motion, Ms. Gardner states as follows. Number one, the state has indicated that it intends to call the following jailhouse informants who are all charged with serious felony offenses such as murder and human trafficking to testify against Ms. Gardner at trial. And then multiple names, I'm guessing 2, potentially more. These informants are all inmates at the Duval County Jail and have so been for some time, as reflected by their jail numbers. They've been there for a long time. Okay. Miss Gardner submitted a public records request for each informant's inmate communications, and so did Lana Oriani. I want all these hoes interviews. Literally. But they came back and said, we cannot give you this. You have to get a court order. It's going to be sealed. I'm trying. Miss Gardner is not seeking judicial review of the claim that the records are exempt from disclosure under the public record statute because they don't want them to go out. But rather the state is seeking to comply. Hey, we need you to get an expedited. We want these now. The state is willing to help out, yes, human traffickers and murderers. These aren't, you're not dealing with jailhouse snitches that are like in for, I don't know, fucking possession. Okay. And Jose Baez is saying, these people have been in there for a long time. And it's like, are these your guys's, like, do you recycle these people? Have they been used in other cases? But great point there, Heather. Yes, we are willing to deal with human traffickers and murderers. Unbelievable. This is exactly what Jose Baez said was going to happen, is that when you can't make a case and you have all this shit, then you're going to go to jailhouse informants. And he put this out there in 2024, and here it is in 2025. The requested materials are needed to review the potential impeachment evidence, including any statements reflecting bias, motive to fabricate, attempts to obtain favorable treatment, or inconsistent statements. Ms. Gardner seeks to have the court issue in order to obtain, everything. Can you believe this shit? Yeah, usually they stoop to drug dealers, drug users. They're using murderers and human traffickers in the Jacksonville Sheriff's Office to literally be informants to cut deals with, that you are going to deal with murderers and human sex trafficking. That's how weak this case is. And this is why I am all for Shanna Gardner should have been out on bail. This is not how you prosecute people. Okay. Trust me, if your case is strong, you're going to get her. Okay. but she should have made bail. They lied so that she wouldn't. Okay. And they wanted bail so badly because of this. Because this is what happens if you stay in jail, then okay, this is what happens. If you are not in jail, this cannot happen to you. There cannot be jail informants. And I don't think that jail informants, it shouldn't be like, get fucked. And how jurors ever even want to believe a jailhouse informant is disgusting to me. This is the amount of weight I'm giving that testimony. 0. Unless I want to hear it recorded. I want to see it with my own eyes. I am not believing a word that this rat has to say. Bye-bye. Not happening. And so after all of this stuff happens, like, I'm going to break it down more at a later live, but you guys need to see. I mean, do you know what this is? You know how many things are listed here? 207. Okay. All this geofencing, these Google search warrants. I couldn't even believe this. They're over here like, hello, we need all these Google warrants and all these devices that you know they exist for other people that were at the crime scene, okay, and around and in the area. And why aren't you giving us these names? Look at this. This is insane. Google search warrant. Need original responsive documents from Google. We received a printed, scanned version that makes Excel sheets. Like, you don't know what they mean. We're missing the device ID map. We need that. And it's all of these devices. And you want to know what? If you don't have them on your map and it's not listed on your map, okay, that you're planning on presenting, like, if we don't have this, that means you're not presenting this. But they exist and they're there. You just took them off. Google search warrant for this one. It's missing Google response letters, Excel sheet with device ID, GPS coordinates, missing account for the devices. I mean, how is all this stuff missing? All this geofencing. Kim Jensen search warrant. Unable to open, view. Do not know if this is due to user error or missing data. Do not know if it's a particular application is needed to open or view this. Kim Jensen search warrant. Jeremy Ordway. He's really, really important. What's his order precluding subscriber notification? Do not have. His AT&T toll records. Henry Tennant's search warrants. His Google. Do not have in usable format. Only have raw data. Henry Tennant's search warrant. This is during the time of the murder. Like, and then all the way until he was arrested on 8/16. Need more identifying information to confirm receipt, as we do not have any records ending on this date. Wild stuff, man. Wild stuff. How does, they're saying that they have multiple Ring cameras. The defense is saying all we have and all we're aware of is from Ring is that you requested that from Mario and the Gardner residence. Where are these multiple Ring search warrants, subpoenas? FDLE surveillance clips, really, really important. Do not have a file with this title. Do not know what these files refer to. Latent prints from shaft of Bush beer can. Do not have any photos or images of prints. Now, I found those in the discovery. They're right at the beginning, but I'm not sure if the pictures are there. But I can definitely tell you that the prints aren't there. Which that tire, or for the beer can, they basically wanted them to process this because they said it was so important in the crime scene in the beginning. Media release images. In a previous discovery download, defense received a folder titled Media Release Images, which contained 3 files, requesting all additional images, reports, data, charts, videos, information, and the like that has been released to the media. Do you know this is going to get a huge... I believe that this is going to blow up when stuff is going to come out that it was leaked that should have never been leaked. It's coming. Okay. Right here, I put in a tip. This video containing the flyover of this address. Okay, there was multiple ones that were done, and I said, "Hey, you need to go and look for the certain dates because they were looking for Henry's truck before they found the tire, and I'm almost positive they found the truck before the tire was planted on the lawn of Henry Tennant's, or the property of Potomac." I did a whole live about it because of the timestamps were off. But they're on it. They're so on it with all of this shit. All right. All statements contained in video clips from Action News Jacksonville. I'm like, wait, what? All statements by BB on video clip from scene provided by crews. All statements contained in screenshots of text messages between KJ and Shanna Gardner. How do they not have these? Need to know how many screenshots there are to confirm receipt. And there's just hella mail. Yeah. All right. Well, come on, join me. We're going to go talk about Charlie Kirk. We're going to go visit campus, and congratulations to Shanna Gardner catching one of the best lawyers out of Ohio, joining her team, Pro Hoc Vice. I swear the last two big trials that I know that she's done, she's got a gentleman, Matthew Moore, was acquitted of murdering his wife, and a friend of mine, her mom was on the jury, and then the doctor with Jose Baez here in Columbus in 2022, he was acquitted of saying that he murdered over, double digits with patients, and then he was applying, he was like a serial doctor killer. So yeah, just go ahead and look it up. Literally, I'm shutting this down and starting right back up. So come on, join me. Check out all this information from Utah Valley University.